Greetings and welcome to Summary Judgment, Condensed from American Jurisprudence, Part 6. Now we're going over a new chapter of determination, governing rules, principles, and considerations. Before we get started, just remind everyone, this is strictly for the entertainment and educational purposes of this YouTube channel and broadcast, not to be misused, or abused for anything legal, lawful, personal, private, business, tax, financial, or otherwise, so please don't do this at home. That said, let's get started where we left off. And that was on section 37, generally. The primary function and duty of the court in passing upon a motion for summary judgment is to determine whether there is an issue of fact to be tried. So, summary judgment will be denied if any genuine issue of material fact exists. The court applies law to admitted facts when no factual disputes exist. The standard is no genuine issue of material fact and movement entitled to judgment as matter of law. So those are the things. There's no genuine issue of material fact and the movement is entitled to judgment as a matter of law. The evidence considered: pleadings, depositions, answers to interrogatories, admissions, and affidavits. Those are the evidence we're looking at, which makes review of these cases simple, because this is the only evidence considered here in summary judgment are the pleadings, your motions, the depositions, the answers to the interrogatories, any admissions, and of course the all-important affidavits. 4 key issues addressed in summary judgment. 4 issues here. Number 1, material facts. 2, elements of the claim. 3, the plausibility, to make sure it's not overly conclusory. And of course, the factual issues. So we have material facts and the factual issues. The elements of the claim, how they connect, and of course, a plausibility to make sure it's not overly conclusory. Now, our practice guide here says, counsel should carefully weigh the consequences of a decision, not to request oral argument on a motion for summary judgment or judgment on the pleadings, because a failure to make such a request may preclude raising the point on appeal, and may constitute a waiver of the rights to oral argument on the motion. Wow, so let's dig in deeper here on this one. This is from American Jurisprudence, of course, the 2008 supplement. And this practice guide here probably still stands. As far as I know, the counsel should carefully weigh the consequences of a decision not to request oral argument on a motion for summary judgment or judgment on the pleadings. Not to request the oral argument on these, because a failure to make such a request may preclude raising the point on appeal and may constitute a waiver of the right to oral argument on the motion. So, as they're stating here almost in the negative, carefully weigh the consequences of a decision not to request. So they're not telling you you should do it, they're telling you you should probably do it. Because a failure to make such a request may preclude raising the point on appeal. So it's probably important to at least request the oral argument on a motion for summary judgment or judgment on the pleadings. So there you go. Excellent practice guide. Preserves it for appeal. Let's proceed. So now we're on to section, let's see here. Sorry about that. All right, let's see here. All right, we got a little more expansion here. The primary function due to the court in passing upon a motion for summary judgment is to determine whether there is an issue of fact to be tried. So the summary judgment is denied when genuine issues of material fact exist. The summary judgment granted when no factual disputes and the movement is entitled to judgment as a matter of law. Federal Rule of Procedure 56C and similar state rules governs summary judgment proceedings. So, of course, we look to that federal rule, and then if there's some local rules that would override that in certain situations, you want to be aware of those. Usually it involves other documentary requirements. Credibility assessments, and time restrictions. Credibility assessments and evidence weighing are matters for the jury, not the court. So save that for later. Summary judgment begins with review of complaint to determine if it states a claim for relief. So review the complaint to determine if it actually states that claim. So elements of the claim. Now we have a qualified immunity test in Section 1983 actions. So this is our first case here for Section 37. In applying the qualified immunity test on a motion for summary judgment in a Section 1983 action, court reviews the facts in the light most favorable to the plaintiff and draw all permissible inferences in the plaintiff's favor. Yeah, in a perfect world. That's Hanron versus Dalling, and that's Second Circuit 2003. So I wonder how that case turned out. Let's proceed here. Arguments not asserted in memorandum. District Court decided cross motions for summary judgment would not consider defendant's line of argument that was not asserted in memorandum supporting their motion. So that's from Doe versus Kamal School Boards. Let's see. Okay. Well, that's in Hawaii in 2003. So there's where the district court deciding the cross motions would not consider a line of argument from the defendants because it wasn't asserted in their memorandum supporting the motion. So make sure those arguments are contained in the memorandum with supporting the motion, or I guess the motion itself. Further discovery required before summary judgment. That's from Mank versus Green, Maine 2004. Further discovery and briefing was required before summary judgment would be granted on claim by employee welfare benefit plan administrator seeking reimbursement of medical benefits paid to accident victim against personal injury attorneys for other appropriate equitable relief. So there you go. Got to make sure those personal injury attorneys pay to accident victim against the personal injury attorneys for other appropriate equitable relief. So let's break this down a little bit better here. The further discovery and briefing was required before summary judgment be granted. Okay. So credibility assessments for jury, not the court. So the credibility assessments, choices between conflicting versions of the events, and the weighing of evidence are matters for the jury, not for the court, on a motion for summary judgment. That's from Moffitt versus that in Vermont 2005. All right, we're on to the failure to comply with the local rules. I said these local rules, very important to be aware of, because the trustee failed to comply with the local rule requiring movement to certify that parties had made good faith effort to resolve dispute, warranting dismissal of trustee's motion seeking summary judgment on claims for breach of contract, breach of fiduciary duty, and violation of Oregon Unfair Trade Practices Act. And that's from Thompson Family Charitable Uni Trust versus Federico, and that's Oregon 2004. Now we're on to the 4 issues to address in your summary judgment motion. Here we go. The 4 issues are to be addressed upon a motion for summary judgment. 1. Whether the moving party has clearly and convincingly established the absence of material facts. 2. If so, whether a non-moving party presented sufficient facts to establish all elements of the asserted claim or defense. And 3. If factual support is presented by the non-moving party whether those facts are sufficiently plausible to support a jury verdict or judgment under the applicable law. So that gets a little tight in there, as we saw before. If the factual support is presented by the non-moving party, whether those facts are sufficiently plausible to support a jury verdict or judgment. Not saying that are they plausible to support a jury verdict under the applicable law, and 4, whether there are any genuine factual issues with respect to those material facts under the governing law. So there you go. That's your 4 points to address in summary judgment. Whether the party has clear, convincingly established absence of material fact. Because to have a summary judgment means there needs to be no material fact issues. And then 2, if so, because if not, that's not going to succeed there with that summary judgment. So if so, whether the non-moving party presented sufficient facts to establish all the elements of the asserted claim or defense, point by point, usually by affidavit, unless you can do all of that with your other admissions and answers to interrogatories, depositions, etc. And 3, if factual support is presented by the non-moving party, so we've done 1, 2, and 3, whether those facts are sufficiently plausible. So we need to make sure it's even plausible for these facts, even though you've established them. And then 4, finally, whether there are any genuine factual issues with respect to those material facts under the governing law. So then we check the governing law 4th. So grueling 4 points, but there they are. Now we're on to summary judgment standards applicable to habeas petition. Summary judgment standards were applicable to a state's motion to dismiss prisoner's habeas corpus petition for failure to state a claim upon which relief could be granted, where both parties presented material outside pleadings and state gave notice to petitioner that rule governing motions for summary judgment would apply. And that's Tyler versus McGodtree. It's Wisconsin 2003. All right, hope everyone is still here. I do believe I have the talking chat enabled, so if you put something in the chat, we'll definitely get our attention.
The tribe says, hit the like.
Indeed, it is working. And that way, if you have any questions, comments, or any other suggestions to put in here regarding the text, feel free to pipe up and join in. Let's continue. Summary judgment is appropriate when no
Facetium Sexpert 587 says greetings.
Greetings to you too. So as you see here, this is an interesting one we just went over here. The summary judgment standards applicable to the habeas corpus petition. So when there's a failure to state a claim upon which relief could be granted, where both these parties are presenting materials outside the pleadings. So failure to state the claim, so then they're presenting material outside the pleadings. And the state gave notice to the petitioner that the rule governing the motions for summary judgment would apply. So there you go. State dismisses the motion for failure to comply. All right, summary judgment appropriate when no genuine issue exists. Summary judgment is appropriate where, as a matter of law, it is apparent from the pleadings, depositions, affidavits, or other evidence that there is no genuine issue of material fact and the moving party is entitled to relief as a matter of law. And that's from the Florida Bar versus Green in 2006. So this is a nice succinct statement here about summary judgment appropriate when no genuine issue exists. Summary judgment is appropriate where, as a matter of law, it is apparent. So it's going to be apparent from the pleadings, depositions, affidavits, or other evidence. So all of this has to be no genuine issue of material fact, and the moving party is entitled to the relief as a matter of law. All right, so we had the 4 points before. Now we have 3 conditions for summary judgment. Summary judgment is appropriate if 1, no genuine issue of material fact remains. 2, the moving party is entitled to judgment as a matter of law. And 3, it appears from the evidence that reasonable minds can come to but one conclusion, and construing the evidence most strongly in favor of the non-moving party, that conclusion is adverse to the party against whom the motion for summary judgment is made. So third condition is pretty strong. It appears from the evidence that reasonable minds can come to but one conclusion. And construing the evidence most strongly in the favor of the non-moving parties we saw there, that conclusion is adverse to the party against whom the motion for summary judgment is made. So there it is. That's State Duncan versus Mentor City Council. That's Ohio, 2005. And let us proceed. And movement must prove no genuine issue of material fact. The summary judgment movement must prove there is no genuine issue of material fact to prevail on his motion. And that's from SAS Institute versus Britton Field, Texas, 2005. And error in granting summary judgment did not harm insurer. Any error in granting summary judgment that homeowners insurance policy covered loss due to mold did not harm insurer, where sufficient evidence of unpaid non-mold related expenses supported the $1,000 award. Jeez. That's McMillan versus State Farm Lloyd's, 2005 in Texas. Over 1,000. All right. Then we have the review of complaint and answer in summary judgment. Every decision on motion for summary judgment begins with a review of the complaint to determine whether, on its face, it states a claim or relief. If it does, the court examines the answer to see if issues of fact or law have been joined. Nice. And that's from Butler versus Advanced Drainage, Wisconsin. Now the review of complaint and answer in summary judgment. Every decision on a motion for summary judgment begins with a review of the complaint to determine whether, on its face, it's the same thing we just read. All right, so Jackson County. Wow, so Natural Resources, and this one's Wisconsin 2006 also. Different page, so wow. I guess they used some boilerplate there in that court, didn't they? Let's move along. Yeah, you know what? Just a moment here. I think I need to check something just to make sure it is indeed correct there. I'd hate to think that I get some citations wrong. I'm not going to let that slide. Let me check real quick here. That was in section 37, right? Let's see here, Wisconsin. On its face, determine whether, yeah, indeed. So there it is. Okay, no worries there. Let's proceed. Yeah, so it's I guess they're using some boilerplate stuff there on that day, which wouldn't surprise me. Let's see what it say here. Every decision on a motion for summary judgment or when deciding a motion for summary judgment. Does court examines? Yeah. Okay. So in 2006 in Wisconsin, I guess they were using the same responses for the same subject matter like that, but I thought mostly on appeals they were supposedly different. I digress. Let's continue. Section 38 now. Discretion of court. Caution in awarding summary judgment. This section addresses the court's discretion in summary judgment motions and emphasizes the need for caution when granting summary judgment. The trial judge may perform negative discretionary function and deny summary judgment even if justifiable. Wow. So the trial judge may perform negative discretionary function and deny summary judgment even if it's justifiable. So that's some strong discretion there. Negative discretion No discretion to award summary judgment if standard has not been met. So if there's no standard, then they cannot award summary judgment. Summary judgment is a drastic remedy requiring caution. The court may deny summary judgment if better course would be full trial. And any doubt as to existence of factual issue must be resolved in favor of opposing party. Now we have a caution. Summary judgment should never be granted unless the facts are clear and undisputed. Any doubts as to whether there is an issue of fact must be resolved in favor of the party opposing the motion. Let's continue with some cases with the discretion of the court. Caution in awarding summary judgment. A likelihood of confusion at summary judgment stage. Due to the factual nature of likelihood of confusion, determining whether a likelihood of confusion exists at the summary judgment stage is generally disfavored, because a full record is usually required to fully assess the facts. That's KP Permanent Makeup versus Lasting Impression, 2005 Ninth Circuit. Then we have evidence viewed in light most favorable to the non-moving party. When considering a motion for summary judgment, the trial judge must view the presented evidence in a light most favorable to the non-moving party. And that's Dalton versus Camp. And it looks like North Carolina, 2001. And then summary judgment must be awarded with caution. Summary judgment must be awarded with caution, reflecting the court's discretionary function to deny summary judgment even when it might be justifiable. So there you go. The caution reflecting the court's discretionary function, including their negative discretionary function, and that's Sinot versus Aquachem, Ohio, 2007. Now we're on to Section 39, Determining Issues of Fact. The section now explains the court's role in determining whether factual issues exist that require trial, rather than those issues of fact. We have the court's province is to determine whether issues of fact exist, not to try those issues. So it's the court's area of responsibility to determine whether those issues of facts exist, not to try those issues. They just need to determine whether they exist. The court must make preliminary assessment of evidence to determine if it concerns material issues. They must, this is important, must make preliminary assessment. The courts must determine if evidence is more than de minimis. Important there. And then affidavits and summary judgment proceeding stand on different footing than in trials. Wow, so different evidentiary standard it seems here. And then summary judgment affidavits are analogous to judge directing jury verdict on admitted facts. Wow, so there's something different there with the summary judgment affidavits are analogous to a judge directing jury verdict on admitted facts. Well, let's read some of these cases. Let's see how that pans out. So we have a court of appeals decides judgment appropriateness, where the parties agree that there was no genuine issue of material fact on a motion for summary judgment. The Court of Appeals decides whether judgment is appropriate as a matter of law. That's Fitzgerald versus Camdenton School District, 8th Circuit, 2006. Affirming summary judgment on unaddressed ground. The Court of Appeals may affirm a grant of summary judgment on the ground supported in the record, but not addressed by the district court, if court concludes that there was no genuine issue as to any material fact and the non-moving party was entitled to judgment as a matter of law. On the ground supported in the record, but not addressed by the district court. All right, so that's Aquatex Industries versus Technic Solutions. So it was in the record, but it wasn't addressed. Okay. Material facts without proper citation deemed admitted. But material facts. So when evaluating a motion for summary judgment by a university health center and its chancellor in African American employees' race discrimination action, district court would deem all material facts set forth in defendant's motion as admitted. Where material facts that employees submitted in opposition to motion did not contain any citation to either affidavit of witness competent to testify as to facts at trial or other admissible evidence in accordance with the requirements of the local rule. That's interesting there. So the evaluating the motion for summary judgment by University Health Center as chancellor, the district court would deem all materials set forth in defendant's motion as admitted. Where material facts that employees submitted in opposition motion did not contain any citation to either affidavit of, So whatever facts were put in there that weren't contested, it seems like, were deemed all material facts admitted. All right, so that's word to the wise. Always address all the allegations or alleged facts point by point with your contravening rebuttals in an affidavit, preferably. And that's Ozine versus University of Connecticut Healthcare, Connecticut, 2003. I digress. All right, so now we're on to alternative procedure when summary judgment is unavailable. Where summary judgment is unavailable due to presence of genuine and material factual dispute, court may instead utilize procedure under different federal rule for making findings of fact on disputed issues before ruling on legal merits of case. So there's alternative remedies. That's Mobley versus Continental, DC 2005. Now we have genuine issues.
Bill 4426 says, I am having some connection issues.
All right, let me double check everything on connection issues here. And while we're doing that, let's double check here. And if you haven't already, please hit the like so we make sure we get notifications out, as many people in here as possible. And it looks like our connections are going good on that end. And it looks like here on the YouTube end,
Bill 4426 says it might be me this time.
But it's always good to double check. And let's see here, our stream health seems to be all right on this side. Let's see here. Okay, excellent condition. Yeah, we should be good. All right, might be you that time. I hope everything's going good now. We're almost done with section 39, so let's finish this here. The genuine issues of material fact regarding a bonus owed. Now, this is important here because you don't want to be losing that bonus owed. Genuine issues of material fact existed as to whether a bankrupt debtor owed bonus to obligor of breached promissory note, precluding summary judgment on obligor's set-off counterclaim under Georgia law. So that's from the Bankruptcy Court, Northern District of Georgia, 2003, and Ray, Flooring America, Incorporated. So a genuine issue of material fact as to whether the bankrupt debtor owed the bogus, whether the debtor owed a bonus to the obligor of a breached promissory note, precluding summary judgment on the obligor's set-off counterclaim. Okay, so the set-off, I see, because there is a material fact whether they owed that bonus, even though it was a breached promissory note, there must have been some bonus. All right, fact questions resolved by reference to administrative record. So under the Court of Federal Claims rule governing a motion for judgment on the administrative record, the existence of a fact question neither precludes the granting of a motion for summary judgment nor requires the court to conduct a full-blown evidentiary proceeding. Rather, such fact questions must be resolved by reference to the administrative record as properly supplemented as if the court were conducting a trial on that record. Wow, from the administrative record. Reference the facts. International Outsourcing Services, LLC, 2005. All right, let's move along. All right, now we're on to Section 40, the court's entry of summary judgment sua sponte. This section addresses the court's authority to enter summary judgment sua sponte on its own initiative and the procedural requirements for doing so. Federal Rule 56 does not explicitly authorize sua sponte entry of summary judgment. Courts disagree on propriety of sua sponte summary judgment entries. And before granting a sua sponte summary judgment, the court must assure itself that Rule 56 procedures would not alter the outcome. Remember, the court's not supposed to be doing this on its own initiative. The courts must give parties notice and an opportunity to be heard before granting sua sponte summary judgment. An exception to notice requirement exists when issue is purely legal, record is fully developed, and failure to give notice does not prejudice a party. Wow, so the district courts possess power to enter sua sponte summary judgment. District courts possess the power to enter summary judgment sua sponte so long as the opposing party was on notice that she had to come forward with all of her evidence. And that's Dudley's Commercial and Industrial Coding versus USIRS. Okay, that's Tennessee 2003. Let's move along. So we have the sua sponte grant without notice, not preferred. Sua sponte grant of summary judgment without giving notice to the parties is not the preferred method by which to dispose of claims, not only because the district courts run the risk of unduly prejudicing parties, but also because such grants of summary judgment can have serious, if unintended, consequences. That's Gibson versus Mayor and Council of the City of Wilmington, and that's in the Third Circuit, 2004. Then we have definition of notice in sua sponte context. Well, yeah, what's the notice they're talking about here? In context of sua sponte summary judgment, notice means that the targeted party had reason to believe the court might reach issue and received fair opportunity to be heard to put its best foot forward. So, that's Gibson versus Mayer again in 2004. Then we have the exception to the notice requirement. Yikes. The exception to the requirement of the district court give parties notice before sua sponte granting summary judgment exists. Here's their exception. When the following conditions are met. Here's another three. 1. The point at issue is purely legal. 2. The record was fully developed. And 3. Failure to give notice does not prejudice the party. Same case, that Gibson one. So, important case, it looks like Gibson versus Mayor and Council of City of Wilmington. And it refers to the Federal Rule of Evidence also. Here is service and Rule 63. Let's move along. And sua sponte grant without notice where conditions are met. The district court could sua sponte grant summary judgment to mayor and city council, well, the same one, in police officer's claim that he was terminated pursuant to an overbroad and vague police department directive, which infringed on his First Amendment right to free speech, without first giving notice to the officer. Where point at issue was purely legal, record was fully developed, and failure to give notice did not prejudice the officer. Wow. So that case looks like it is pretty interesting there. Let's continue. Discretion to grant non-moving party summary judgment. District Court maintains discretion to grant non-moving party summary judgment even where non-movement does not file cross motion for summary judgment. That's Acton versus Columbia, and that's 8th Circuit 2006. So they can grant sua sponte cross. Non-movement doesn't file the cross. So it grants a non-moving party the summary judgment. Yikes. Sua sponte grant appropriate when evidentiary materials are before the court. where it appears clearly upon the record that all of the evidentiary materials that a party might submit in response to a motion for summary judgment are before the court, a sua sponte grant of summary judgment against the party may be appropriate if those materials show that no material dispute of fact exists and that the other party is entitled to judgment as a matter of law. That comes from MSF Holding Limited versus Fiduciary Trust Company, Southern District of New York, 2006. All right, now we're on to section 41, hearing and oral argument. This section addresses the procedural requirements and discretion regarding hearings and oral arguments on summary judgment motions. So Federal Rule of Civil Procedure 56C contemplates hearing at least 10 days after service of motion. So another time to remember here under Federal Rule 56 contemplates hearing. Is your hearing and your oral argument at least 10 days after the service of the motion. Courts may provide by rule that oral argument must be requested, otherwise deemed waived. Wow, they may provide that rule, so check your local rules. Some courts hold oral argument not required before rendering summary judgment. Other courts hold that oral argument required unless specifically waived by all parties. And decision to hold hearing on summary judgment is discretionary, not mandatory. So, practice guide here. Counsel should carefully weigh the consequences of a decision not to request oral argument on a motion for summary judgment or judgment on the pleadings, because the failure to make such a request may preclude raising the point on appeal and may constitute a waiver of the right to oral argument on the motions. Sometimes you have to literally go through the motions to preserve the appeal. Great practice guides. Similar theme in this section for sure. All right, let's look at some of the cases here. Motion ripe for disposition following conversion. Both sides received reasonable opportunity to be heard, and therefore a motion to dismiss was ripe for disposition following its conversion to motion for summary judgment with respect to defense of latches, so the time expiring. That's Sierra Club versus U.S. Department of Transportation, Nevada, 2003. Then the hearing on summary judgment is discretionary. The decision to hold a hearing on a motion for summary judgment is discretionary, not mandatory. That's Logry versus Rogers Group, and that's Arkansas, 2002. And discretion to hear oral testimony. It is within the trial court's discretion to hear oral testimony on a motion for summary judgment. That's Rhodes versus Okamura. That's Hawaii, 2002. All right, that brings us to my favorite part now. We get a fun quiz to see if you can test your knowledge and see if you learned something about summary judgment tonight. So, if anyone's there and is familiar with the procedure here, we answer in the chat by putting the question number and a letter of the interest of the answer. So if you wanted to pick question 1, letter C, you put 1C in the chat, and that would be your selection, and then we'll check the answers at the end. So let me start with reading out question 1. What's the golden rule when a judge considers a motion for summary judgment? So they got their golden rules. Let's see, is it A, always grant if there's any doubt, or B, always deny if there's any doubt, C, never grant without full hearing, or D, grant only if movement proves their case? So if anyone's still there in the chat and wants to pipe up, pick an answer for what's the golden rule when a judge considers the motion for summary judgment. Golden rule, always grant if there's any doubt, always deny if there's any doubt, never grant without a full hearing, or grant only if the movement.
Built-in 4426 says 2C.
All right, we get an answer for C. Never grant without full hearing. All right, noted. And let's move along to the next question here. Oops, what happened there? There we go. So, when can a judge enter summary judgment sua sponte, on their own? So on their own initiative, without the party having to actually file a motion for summary judgment, the judge awards it and orders it. So is it A, never, it's always improper? Is it B, only if both parties consent? Is it C, only when record is fully developed? Or is it D, when no material facts are in dispute? So sua sponte, on their own initiative, the judge. When can a judge enter summary judgment sua sponte, on their own initiative? Is it A, never? B, only if both parties consent? C, only when the record is fully developed? Or is it D?
Built Image 4426 says correction 1B.
Okay. Oh, we'll accept that correction there. You can go ahead and delete the 2C. I mean I'm sorry, the 1B. Where is it? Oh, you put 2C.
Facility 6412 says capital C.
Never mind. I'm reading the chat wrong here. All right. So yes, I see here we have a 1B, and then for 2 you picked C. Got it. And C for one wise lady, is that for question 2, right?
4426 says I stick with 2C.
Okay, gotcha. And I think that one wise lady is referring to question 2 for C as well. I would suspect that's the answer there. Let's move along. We're on to the next set of questions here. So question 3. So put 3 and then your answer in the chat. Which evidence has different footing?
Facility 6412 says wasn't here for 1, sorry.
Oh, well, we got to go back to 1 then. We can't let that skip by. So question 1 is, what's the golden rule when a judge considers a motion for summary judgment? What's the golden rule? Is it always grant if there's any doubt? A. Is it always deny if there's any doubt? B. Is it never grant without the full hearing? C. Or is it grant only if the movement proves their case? D. So those are your choices for question 1, the golden rule when a judge considers a motion for summary judgment. What's their golden rule? That's why these are kind of very absolute. All right, you can contemplate that. I'm going to move along here.
Let's get back. Facility 6412 says you.
You, okay. We'll go with you. So we have for question 3, which evidence has different footing in summary judgment compared to trial? Wow. So is it A, depositions, B, affidavits, C, interrogatories, or D, admissions? All these are evidence for summary judgment, but which one has...
Facility 6412 says 1C.
1C. Okay, gotcha. Got you down for 1C. Move along to question 4.
Built Image 4426 says 3B.
3B, affidavits. Okay. Different footing in summary judgment compared to trial. Saying affidavits. All right. Any other takers for question 3 before we move on to question 4? Questions 3 should be pretty simple since we only have these 4 selections.
Facility 6412 says 3C.
3C, different footing than in trial. All right, well, let's think about that. But before we do that, let's move on to question 4. Because 4 is about the magic number. This isn't the usual magic number. This is just the magic number of days before a summary judgment hearing. All right, so we have A, 3 days. 3 may be a magic number, but I'm not sure the 3 days is the magic number of days before a summary hearing judgment, but you may select that if you choose. There's B, 7 days. There's C, 10 days. And there's D, 14 days. So what's the magic number of days before a summary judgment hearing? Just recently went over this one of those special time periods, along with the other ones we're supposed to remember from Rule 56, which could vary by state, but I believe this one is pretty standard across the board. The magic number of days before a summary judgment hearing from the motion. So from the time serving the motion.
Judgment 4426 says 4C.
4C. All right. So we got a 4C. Any other takers for question 4 before we move on to the answer key? All right. Going, gone. We're going to the answer key now.
On the facility 6412 says would have thought 4D more, but 14.
14.
Filterman 4426 says low confidence on 4.
Well, since you mentioned 4, we'll get right to question 4 first. What's the magic number of days before a summary judgment hearing? We just read this one. It was 10 days. The Federal Rule of Procedure 56C requires at least 10 days notice before a hearing on summary judgment.
Facility 6412 says I'm drunk.
That's all right. So, all right, so there it is. So 4C, 10 days. So 10 days from the time it's served, the notice is served before the hearing. So there's your 10 days, and that's Federal Rule of Procedures, pretty much adopted state by state. Now we went over the magic number. Now let's look at the golden rule when a judge considers a motion for summary judgment. And the answer for one was B, to always deny it if there's any doubt. Summary judgment should never be granted unless facts are clear and undisputed. Any doubt must be resolved in favor of the party opposing the motion, the non-moving party. That was from Section 38, discretion of the court, the caution in awarding summary judgment. Question 2. When can a judge enter summary judgment sua sponte on their own initiative? And the answer is D, when no material facts are in dispute. While sua sponte entry is not preferred, courts may grant summary judgment when no material facts are in dispute, and the movement is entitled to judgment as a matter of law. And that's from our Section 40 about sua sponte entry of summary judgment. And finally, question 3. Which evidence has different footing in summary judgment compared to trial? And of course it's affidavits, because affidavits in summary judgment stand on a different footing than those which a trial judge is determining a question of fact on affidavits. The latter situation corresponds to that of a judge directing a jury to render a verdict on admitted facts in the plaintiff's favor. So these affidavits, remember, it's analogous to a judge directing a jury to render a verdict based on the admitted facts in the plaintiff's favor. And that's the Section 39, determining the issues of facts. So, and of course our magic number is 10 days after notice before the hearing. So, that said, it brings us to the end of our quiz and our little chapter here on summary judgment. This is the determination with the governing rules, the principles, and considerations. And that brings us to the end of this section. We'll be ready for the next section. So I really thank you all for being here and attending and participating and learning something along with me on this and testing your knowledge at the end to add a little bit of some interaction here. I'd like to invite you all to make sure you're subscribed to get notified of the next episode. We'll be doing part 7 soon, and we're just about done with this entire volume of summary judgment from American jurisprudence, taking it a little section by section to make it a little bit more fun and digestible, and provide us with some memory aids too. So hopefully be able to use this should it ever become necessary. Hopefully not, but as the saying goes, preparation is the best form of prevention. That said, I'd like to thank you all.
On facility 6412 says, got a lot to catch up with. Really loving your content.
Well, thank you very much, One Wise Lady. I'm trying to condense this down to most manageable chunks I can while keeping it coherent. So I'm going to keep chugging along with this, and hopefully you all stick along for the ride, and we'll all learn something at the end of it. That said, salute to you all for being here, and I'll see you on the next one. Peace out.
Bill Famous 4426 says, take care all.